The Arbitration and Conciliation Act 1996 provides a legal framework for arbitration in India. It emphasizes party autonomy, minimal court intervention, and speedy resolution. The Act covers both domestic and international arbitration, ensuring enforceability of awards. It also includes provisions for conciliation, promoting amicable settlements outside court.
Arbitration is an alternative dispute resolution method where parties resolve conflicts through an impartial arbitrator whose decision is binding. It is voluntary, contractual, neutral, and confidential, with awards enforceable like court decrees. Arbitration covers commercial, civil, and international disputes, excluding criminal and certain family law matters. Arbitration offers efficiency with faster resolutions than courts, and flexibility as parties set procedural rules, language, and venue. It's cost-effective, allowing reduced legal expenses. Expertise is ensured by appointing knowledgeable arbitrators. Confidentiality protects sensitive information, while party autonomy provides control over the process. Cross-border enforcement is facilitated by conventions like the New York Convention. The Arbitration and Conciliation Act, 1996, as amended, forms India's legal framework, aligning with United Nations Commission on International Trade Law Standards. An arbitration agreement must be in writing, indicating intent to arbitrate and cover specific legal relationships. Both arbitration clauses within contracts and separate agreements are valid, ensuring flexibility in dispute resolution. The composition of an arbitral tribunal is crucial. Parties can decide the number of arbitrators, with a default of one. Appointments are made by parties or courts if disputes arise. Arbitrators must be impartial, and any conflict of interest can lead to challenges under Sections 12 to 13 if bias or incapacity is suspected. The tribunal's jurisdiction includes the competence principle, allowing it to rule on its own jurisdiction. The doctrine of separability ensures the arbitration clause is distinct from the main contract. Tribunals and courts can grant interim measures. Venue and language are determined by parties or tribunal, with default rules if not specified. Arbitral proceedings offer procedural flexibility, allowing parties or the tribunal to set rules, timeframes, and evidence protocols. Equal treatment is mandated, ensuring both parties can present their case. Submissions include oral and documentary evidence with witness examination. If a party fails to appear, ex parte proceedings may occur under Section 25. Arbitral awards must be in writing, signed, dated, and state the arbitration location. They should provide reasons unless agreed otherwise. Types include final awards, resolving disputes conclusively, interim awards, addressing parts of disputes, and partial awards, focusing on specific claims. Awards have a 12-month time limit, extendable by 6 months. Proceedings conclude with a final award, as per Section 32. Alternatively, parties may settle, resulting in a consent award under Section 30. If a claimant withdraws or fails to prosecute, proceedings may also be terminated. These mechanisms ensure efficient resolution and closure of arbitration cases. Post-award corrections and interpretations are crucial. Section 33 allows for correcting clerical or computational errors. Parties can request interpretation for clarification. Additionally, if any claims were unintentionally omitted, an additional award can be issued. These measures ensure the award's accuracy and comprehensiveness, maintaining the integrity of the arbitration process. Setting aside an award under Section 34 involves challenging it on grounds such as party incapacity, invalid agreements, procedural irregularities, or awards exceeding arbitration scope. Additionally, conflicts with India's public policy, like fraud or corruption, are considered. Challenges must be filed within 3 months from the award's receipt. Domestic awards become enforceable as a court decree once the challenge period ends. Foreign awards are governed by the New York and Geneva Conventions. Grounds for refusal and enforcement are akin to those for setting aside, focusing on jurisdictional application. Appeals under Section 37 are limited to specific orders, such as those refusing arbitration referrals or granting interim measures. Setting aside awards is also appealable. However, interlocutory orders and procedural decisions are not subject to appeal. Revisions are permitted only in exceptional cases involving significant procedural errors. Recent developments in arbitration include fast-track processes, institutional arbitration, and confidentiality norms. Technological innovations like virtual hearings and AI tools enhance efficiency. There's a growing emphasis on institutional arbitration with bodies like Mumbai Center for International Arbitration and Singapore International Arbitration Center. Internationalization ensures cross-border recognition and enforcement of awards, strengthening arbitration's global role. Arbitration provides a balanced and efficient dispute resolution method. Recent reforms enhance India's international arbitration role, though enforcement challenges persist. With its speed and finality, arbitration is set for robust growth, bridging the gap where justice delayed is justice denied.